State your name.
My name is Daniel McGoo, for the record, Your Honor.
You're going to represent yourself in this matter, sir?
Yes, sir.
I do have to advise you that in this case, you are charged with the offense of assaulting, resisting, or obstructing a police officer. That is a high court misdemeanor felony, punishable by up to 2 years and or $2,000 fine plus court costs. You understand that?
I understand your charge.
You understand also that there is great peril in one representing themselves. You understand that, sir?
I'm not afraid, Your Honor.
Did you understand what I just said? That there is great peril in representing oneself.
I comprehend what you're saying, Your Honor.
Hey, what? Either you're going to answer my questions and you're going to answer them properly, or we're going to have a long time and I'm not going to have these people wait. So while you decide how you're going to handle this, I'm going to have you have a seat. I'm going to pass your case. You will come back up and you will learn how to operate within this court. Plain and simple. Have a seat. Have a seat.
A man identified as Daniel MCU appears before the court, choosing to represent himself in a serious assault case involving a police officer. The judge immediately warns him about the high stakes, up to 2 years in prison and heavy fines. Despite repeated caution about the dangers of self-representation, Daniel insists he understands. Tension rises as the judge questions his attitude and signals strict control over the courtroom.
And you might want to wipe that smirk off your face while you're doing it. State your name.
Good afternoon, Your Honor. My name is Daniel McGoo.
I have stated the admonishments that I was giving to the defendant representing himself. I apprised him of the maximum penalties and the charges. Apprised him, and sir, I'll ask you the question again. You understand that there can be great peril in representing yourself?
I fully recognize and acknowledge the seriousness of the charges. With allegations of...
Not my question. You understand that there can be serious peril in representing yourself?
I recognize what you're saying. I'm fully prepared to proceed with this matter.
Will you just do me a favor and answer my question? Do you understand that there is great peril in representing oneself?
I recognize that.
Okay, let's stop there. You recognize that.
Recognize.
Do you understand that that in any of the proceedings that the court would hold you to the same as if you were a practicing attorney, will give no leeway one way or the other, will show no favoritism?
The courtroom tension intensifies as the judge repeatedly asks Daniel if he understands the legal risks of defending himself. Instead of a direct answer, Daniel keeps responding indirectly, saying he recognizes the statements. The judge grows increasingly frustrated, demanding a clear yes or no. The situation escalates as Daniel is told to sit down after failing to respond properly, signaling early courtroom control issues.
Or no bias, because you are representing yourself. You understand that, sir?
I recognize what you're saying, Your Honor.
You know what? I don't know why you just won't understand. I'm asking you, and I need a direct answer, whether you understand what I am saying, not whether or not you're recognizing the words. Do you understand what I am saying?
I overstand what you're saying.
You want to be...
Your Honor.
You have a seat.
I'm not...
Have a seat.
Your Honor, I haven't had...
Have a seat. You can play games with me all day. I got all day. I got all day. Have a seat.
After a brief courtroom break, proceedings resume with Daniel still representing himself. The judge restates the legal warnings and seriousness of the charges. However, Daniel continues to respond in unclear language, avoiding a direct acknowledgement. The judge insists he will be treated like a lawyer under court rules. Daniel begins to show visible confusion and frustration as communication breaks down further.
The other one's in custody. I realize we are now at least caught up within an hour. I think those that want to go probably want me to take a break about now. So I'm going to take about a 5 to 10 minute break. I'll come back out and then I'll call the case. The court's going to stand in recess.
Good afternoon, Your Honor. Daniel Magoo. Here in Dewey Juris.
All right. So on this matter, I was apprising you of your rights. I told you about the charges in this case. To get to the point of understanding that there is a certain peril in representing.
Listening, sorry. My notes, I apologize, Your Honor. I meant no disrespect.
And that the court will treat you the same as an attorney in the case. You understand, sir? Listen closely to my question. Do you understand that?
I do not understand.
You do not understand it.
No.
Daniel openly states he does not understand the charges, arguing violations of his rights and lack of proper evidence disclosure. He references constitutional protections and due process, insisting he has not received full discovery. The judge repeatedly redirects him, asking for a simple confirmation of understanding, not argument. The exchange becomes heated as Daniel shifts between legal claims and confusion over the charges.
The court, you will be presumed to know the rules of procedure as well as the Michigan rules of evidence, that the court will not be giving you assistance in regard to this case.
What I'm trying to say, Your Honor, is I do not understand the charges that are pitting against me because they violate a lot of my rights. And the prosecutor served me the discovery packet on the 27th of last month. Since then, I have not received any kind of evidence or any kind of claims that I violated any kind of anything that day. So I'm here waiting for that to occur. So no, I don't understand.
Waiting for what to occur?
Well, under the rights to due process, Your Honor, 4th, 5th, 8th Amendment, there has to be substantiated amount of evidence to accuse me of a crime, like assault on a police officer, obstruction of justice, and
The judge loses patience as Daniel continues arguing and interrupting. He warns him repeatedly not to speak over the court and finally adjourns the case to give him time to reconsider legal representation. Daniel insists on his rights and refuses to fully comply, leading to further tension. The judge ultimately offers him the option of an attorney, stating one can be appointed if he cannot afford it, before moving the case forward.
resistant arrest. I take these charges very serious, Your Honor. Because of these charges, I have lost custody of my son, and I want to make sure that these justice is served and equity is ensured here.
Sir, I just asked you before whether or not you understood the charges.
And I answered you, Your Honor. I said I do not understand them.
Whether or not you disagree with them or not the issue. The issue is do you understand what you are charged with?
Do not understand, Your Honor.
Is there a reason other than what you said that you do not understand?
I can elaborate a little further, Your Honor. I'm still waiting.
I wish you wouldn't. I just need to understand why you don't understand.
I'm trying to get there, Your Honor, if we could talk about it.
I'm not asking you whether or not you agree that you should be charged. I'm not asking whether or not you believe that you did it. I'm not asking any of that. I'm asking whether or not you understand what you are charged with.
Can we agree to disagree on the legalese?
We are not going to agree to anything. This is not your game to play here. You play by my rules.
So you're saying that I have to say the words, I understand?
Sir, I'm not saying that you have to say anything.
Okay.
You know what? Here's the thing. I am not going to play this game with you.
I'm not.
So what? No, you are playing a game.
not.
So no, you are. And do not interrupt me ever again. Do not. So what I'm going to do is I'm going to give you a week to think about it, because I'm not going to sit here, call your case up 4 or 5 times